Hello, I'm Leslie Owens. My husband and I are the parents of two adult children. Our son has an autism spectrum disorder. I am a retired speech language pathologist. I do volunteering in my retired days now, and I continue to be an advocate for my son.
Thanks, Leslie. So, do you have some tips and strategies that you have used, or what kinds of unique situation do you have set up for your son and decision making? Did you do guardianship, power of attorney, or some kind of limited or letter of intent?
Okay. My son is his own guardian. We made that decision along with our attorney and some input from him when he was about 20 years old. We did this at the same time that we were establishing a special needs trust for him and updating our estate papers, such as our wills, that kind of thing, as he transitioned from being under 18 to over 18 at the time. We also did a durable power of attorney for him and a healthcare power of attorney with named trustees. We do have a letter of intent that is filed with our other papers that stipulates his need for a guardian of sorts, but not in the legal sense. Our son has always wanted us to be present and guide decisions and help him in many ways. When he's talking to someone on the phone about his matters right now, whether it be the Cleveland Clinic or somebody else that might call him, he's very comfortable saying, "I give you permission to talk to my mother." We feel very, very fortunate in that respect. Our decision was made and guided by who he is as a person, his level of understanding, his capabilities, his strengths, his challenges, his ability to make decisions on his own or those that he needs support with, his vulnerabilities, which are huge and something that we spend a lot of time talking about related to guardianship, his ability to communicate his wants, desires, and needs. His level of functioning on a day-to-day basis was also a huge consideration. He clearly understands that this legal stuff, the government stuff, and even medical matters and money matters are overwhelming, and he knows that he could not navigate without support. There are many things he can do, however, and our decision at his age of 20 really came after watching him through his teenage years, middle school and high school, where his future path was still really not very clear. You know, in the early days, he had some of his own money in an account. We weren't sure if he was going to be a college-bound student, if he was going to be a vocational student, you know, what his ultimate work life would be like. So by the time he was 20, it was very clear sort of what path he was taking, and that's probably coincided with our decision to do the trust and also truly decide that he was going to be his own guardian.
Good. So, you mentioned you had an attorney assist. Did you have other agencies, like some families use the County Board of Developmental Disabilities? How did you come to know that you needed an attorney? Did you have support through our other support agencies?
At the time, we only used our attorney, and it probably came in our discussions about the Special Needs Trust, updating our wills and our estate papers as to what would happen to Stephen if something happened to my husband and I. I did not seek any support from the county board at the time. Our son was loosely connected with the county board at that particular time in his life. However, at this time, his support administrator is someone who is listed as part of his team, as someone who, if something happened to my husband and I, she would be a person that my daughter could call, that kind of thing, to be a part of his team. But I think it's because we have a 4 or 5 year relationship with her now. She knows Steve very well, and she is well aware of some of his challenges. There's a good trust between us, I think. So I think she would be very helpful if I were at that decision point now. But I think the county board could be very helpful, again, if the county board support administrator knew the family member really well, even possibly using some of their assessment tools for eligibility, or possibly their tools that they use for someone's capacity for independent living, in terms of how's someone communicating, their decision making, their judgment. But I think that would be a family's decision on, how well the support administrator, at least in this case, the key person, really knows the family, the individual, and is there a good trust there?
Have you ever been denied access to your son's information or denied talking with others who help him?
I have not had that experience, thankfully.
And do you have your attorney do any ongoing paperwork? Do you rely on that person? Or do you have any ongoing reporting that you need to do with the power of attorney?
Anything related to things that the attorney did, there's no paperwork other than updating the papers. We just went through that over the past year. We updated all the estate papers, made sure all the language coincided with anything legally that had happened over the years. And because I'm not his guardian, I don't have paperwork related to that. But I certainly have experience related to paperwork with other systems such as Social Security, Medicaid. In fact, I have notebooks of things that I've communicated with on a monthly basis with Social Security. Medicaid is pretty much yearly unless there's changes in employment.
So you mentioned your son and you have had this power of attorney now for a while.
Right.
And it sounds like you have you feel settled in your decision for now. And you probably know that things can change, but at least you have something set up for his safety and long-term needs for now. Can you talk about how important the letter of intent is for you and your son's decision?
I think it's a very important document, and every summer, in fact, it's one of my things to do this summer. I update that along with a couple other documents, and then I always send a copy to our attorney. My daughter has a copy now because she has been added on to all our paperwork behind my husband and I now, because she's of age and has accepted that responsibility. The letter of intent, I think, is a great marker for me because it lets me see over the past year little changes that have occurred with our son, so that maybe we tweak some things. He's doing more things. He's more responsible in this area. On the other hand, there are things that were challenges when I wrote the letter years ago, and they remain challenges. So it's always good to have that, and I think it's what we would like for him in the best of worlds. And also, certainly, what he has said in his own life, what he would like, or, what church he would like to continue with, or activities that he likes, or, his employment may change and things like that. But it does incorporate all of the things that he wants also, because he does speak his mind in terms of what potentially he would want to do if something did happen to my husband and myself. So I think it's a fabulous document, and it's really a place to put your true wants and desires and your family members' desires. I mean, I remember when I was working years ago in Indiana, and I remember working with a family, and they must have done something similar, because in their document, the mother was adamant that should something happen to she and her husband, that her daughter have the most up-to-date hairstyle and have monthly haircuts or whatever. And I remember, as someone without children at the time, wow, she's really covered all her bases. And I still remember that as I think about Stevens. I don't put anything in about his barber, but you can put things as specific as that. It was important to her that her daughter have the most updated hairstyle. So
wonderful. Thank you. So lastly, what important advice do you have for anybody who may be hearing this for the first time? Because there are many different choices that suits anybody's needs. What would you say to someone who's just starting to think about power of attorney, limited guardianship, or guardianship? What are your tips?
My thoughts on that are a couple. First of all, to find a professional who is very well practiced at this whole arena, and then assemble as much as information as possible to be able to show, tell, or help others understand your family member, and again, their strengths, their capabilities, their challenges, their ability to make decisions on their own or with support, their vulnerabilities, their ability to communicate their wants, needs, and desires. I think the more people that you have that really know that individual to really put that down and be able to share that with someone to help you make the best decision. I would also certainly advocate a team approach to this kind of decision. And again, using people that the family or the individual trusts, that know the individual best, and most importantly, have the individual's best interests at heart. Whether that be a next door neighbor, a provider, someone from school. It could be any number of people, but I think the bottom line is, who in your family member's life has their interest, their best interest at heart.
Good. Thank you.